All right, so we begin with identifying what a contract is. So in this topic, we'll be able to understand what a contract is, what are the essential elements of a contract, what are the classifications of a contract, what are the factors that would interfere with the validity of a contract, for example, and we'll also talk about what terminates or ends a contract, and what are the remedies available in case where an individual within a contract has breached his part or his obligations within that contract. So a contract can be defined as an agreement or promise that is between two or more persons, which is legally binding and enforceable in a court of law. I suppose that defines what a contract can be said to be. And I think we also take cognizance of the fact that not every agreement is a contract. So for a contract to be said to be a contract, there are certain essentials of or ingredients that that particular agreement must fulfill. And that is what we are naming the essential elements of a contract. So without further ado, let's go on and discuss the essential elements of a contract. So the first one here is an offer and acceptance. So the formation of a contract begins at the offer. So someone makes an offer and another person will accept the offer. And as a result of that, a contract is made, all right? So there has to be a valid offer and there has to be a valid acceptance for there to result a contract. The other element is intention to create legal relations. So the parties within that contract must be in a position to, or they must have that particular intentions or willfulness to be able to be bound by that particular agreement. So that is why we say social and domestic agreements do not constitute contracts because the parties therein do not have an intention to create legal relations. All right. So an agreement between a husband and wife is merely a domestic agreement, and the two parties do not intend to create legal relations. That's a general rule. It's not always like that, but that's normally the general rule. The other one is consensus ad idem, which is what we call the unity of mind and purpose. So the unity of mind and purpose means that when you are entering into a contract, both of you must clearly understand the terms regarding that particular contract. So there must not be any misunderstanding as to the nature and the purpose of that particular contract. Should there be a misunderstanding as to the subject matter, the nature, and the purpose of that contract, then we would conclude that there was no consensus ad idem, and the agreement therefore does not make it a contract. All right. Then you have consideration, and consideration is referred to as the price for which the promise of offer is bought. So both parties in a contract will have to pay a price, which we refer to as a consideration. So, for example, in a contract between a buyer and a seller, both of them must pay some sort of price. So the buyer pays a monetary price for the goods. The seller, however, the price he pays is that he is going to be less the goods that he's selling. So that is what consideration is, or something in return for something, which we refer to as quid pro quo. So there has to be an exchange of something in return for something for there to be a contract. All right. Otherwise, in the absence of consideration, there cannot be a contract. Right? Then you have contractual capacity. So both parties in a contract must have legal capacity. They must not have any legal disability. They should not be minors or insane or bankrupt during the period to which they're engaging in that agreement. So the parties to the contract must be adults of sound mind. It is not to say that a minor cannot engage in a contract, but the capacity to contract of a minor, of course, is limited to some extent. So the capacity to contract is the ability of a person to participate in a contract. So for you to participate in a contract, you must be of sound mind and be of the right age. All right. Then there has to be free consent. So when you're engaging or entering into a contract, you must freely engage in it without any without any influence from any other, from any other external forces. So you must have participated in that contract, having known the consequences of course engaging in it. So the consent must be willful, and it must be based on the individual's best judgment. So there must not be any person that is interfering with your judgment, so that you only engage in that contract based on the influence of that particular individual. Then the legality of the object, the objective of the purpose for which these parties are contracting must not be illegal, it must not be immoral, neither should it be opposed to public policy. So a contract to commit a crime is illegal, therefore the objective of that purpose makes it an illegal contract and therefore void. And then possibility of performance. Right, so then we have possibility of performance, which means that the contract itself must be it must be possible to perform both legally and physically and legal formalities. Although contracts do not need necessarily to be in any form, there are certain contracts that are required to be in a certain form for them to be valid. Like a hire purchase contract is required to be in writing, for example. So for it to be valid, then it has to meet that particular formality. So in summary, an agreement is going to be said to be a contract if these particular essential elements are present. There has to be an offer and acceptance. There has to be intention to create legal relations, consensus ad idem, consideration, contractual capacity. Those are the main essential elements. But then you have free consent, legality of the object, possibility of performance, and legal formalities. All right. So this brings us here to the classifications of contracts. Right, so there are several ways in which we can classify these contracts. One of the classifications is express and implied contracts. So an express contract are those contracts where the parties have specifically agreed upon the nature and terms of the contract, and they have clearly defined the relationship in that contract. And I've given an illustration here where X states that he will sell his car at 1 million to Y, and Y accepts to purchase that car at that particular price. Now, this contract is an express because the parties have specifically agreed upon the nature, which is a contract of sale of motor vehicle, and they have agreed upon the terms, which will be the pricing and all that, the car itself and all that. Then implied contracts are those contracts where the parties have not specifically agreed upon the nature and the terms of the contract. So to identify whether there is a contract between the parties, we would look at the surrounding circumstances and the conduct of the parties to be able to ascertain whether indeed a contract exists. Like you enter into a matatu, you enter into a hotel you order for a meal. Those are implied. It's implied when you have asked for a menu, that when you ask for that meal, that you will pay for that particular the pricing in that menu. So implied contracts are those contracts where we will be able to ascertain the validity of that contract by the right. So and then we have unilateral and bilateral contracts. A unilateral contract is a contract where only one party is bound by the terms of the contract. For example, where you have maybe you've lost a laptop, you have issued an award for anyone who can be able to return your laptop. It is you see when someone sees that maybe it's a notice that you put somewhere, they do not have an obligation to go looking for your laptop. But if they do find it, you would have an obligation to pay the promised amount. That's a unilateral contract. It's binding upon you, not the other party. But bilateral contracts are going to be binding on the parties, on the two parties in that contract. Then you have valid, void, and voidable contracts. A valid contract will be one where all the essential elements of a contract are there. It is going to be binding and enforceable at all. All right. A void one is where the contract is lacking at any of any legal effect. And therefore, it is neither binding nor enforceable. Then you have voidable. This is a contract where it is actually binding and enforceable, but it lacks perhaps one or more of the essential elements of a contract, which means that a person who is affected or aggrieved within that contract would have an option to set it aside or avoid it. All right. So it's like a contract entered into by a person who enters into it in a state of intoxication. When he becomes sober, the law gives him an option to avoid it. All right, within a reasonable time upon obtaining that sobriety. And then you have specialty contracts and simple contracts. Specialty contracts are also referred to as contracts under seal. They are contracts that are supposed to be in writing, sealed, and delivered by the party bound to those contracts. Simple contracts are those contracts whose formation is not going to be subjected to any legal formalities. They may be oral, they may be written, implied, also from the conduct of the parties. Right? And then you have enforceable and unenforceable contracts. If it is enforceable, it means that all the elements of a contract are present, and therefore the contract in case of breach can be adjudicated in a court of law. If it's unenforceable, it could be a valid contract, but it cannot be enforced or adjudicated in a court of law in case there is breach of it, or where the parties, one of the parties, or refuses to carry out the terms of that contract. Right? So that means that the parties cannot refer the matter in a court in scenarios where there is breach of it. Then you have contracts oberi mei fidei, or contracts of utmost good faith. These are contracts where one party has certain knowledge which is very critical or important to the contract, and therefore he has an obligation to disclose that knowledge to the other parties for there to be a valid contract. All right? Insurance contracts are the best examples of contracts of oberi mei fidei. As an insured, you have an obligation towards the insured to give the information, of course, to the insurer, so that the insurer can be able to decide whether to insure you or not. That information may be important to help the insurer determine perhaps the premiums payable. So, in contracts of oberi mei fidei, it means that failure to disclose that information, the contract becomes voidable at the option of the other party. All right. Then finally, we have executed and executory contracts. All right. So an executed contract is where both parties have fulfilled their obligations under the contract, and therefore that means that the contract has been executed, and therefore the contract has come to an end or discharged by that performance. All right. We say contracts are required to be performed, or they will be discharged by performance in case where both parties have performed their obligations within that contract to the letter. So there must not be anything that remains to be done under those circumstances. Like, you hired a fundi to make you a suit, you're supposed to pay 5,000. The fundi has made the suit and paid the 5,000. That contract is executed. Then we have executory one. I had posted the recording. Let me just repeat so that for the purposes of those that won't be around, I forgot to record. So let me just repeat on the offer. And I was saying the formation of a contract begins here at the offer. And I was saying the offer is an expression of the willingness to contract on definite terms, should those terms be accepted. And I have said the offerer, when he's making that offer, he's basically expressing that should you accept that offer, that is going to be bound by the terms of it, right? And when he's making that offer, he must make that offer with an intention that is going to be binding upon the acceptance of it. And the person who makes that offer is whom we refer to as the offerer, and the person to whom the offer is made is referred to as the offeree. And I've said types of offers. We have the counter offer, and I've said a counter offer is a change, a variation, or modifications of the terms of the offer by the offeree. So it's a conditional acceptance. So a counter offer is in itself an offer, which the offerer, whose a counter offer is made to the offerer, and he has an option either to refuse to accept it or accept it. All right. And the legal effect is to terminate the original offer. So, for example, you're selling someone a car for 500,000. He tells you that he cannot buy that car for that amount. He can only buy it for 450,000. That's a counter offer. You have two options. You can refuse to accept the 440 and 50, and therefore terminate that particular counter offer, or you can decide to accept that particular counter offer. But the effect of a counter offer is that it will terminate that original offer. The cross offer is where there are simultaneous offers that are made by two persons over the same subject matter and at the same terms. And this is normally without the knowledge that each has actually made that particular offer. So you're offering you owe X through an email offers to sell his car for 500,000. All right. Why? Without knowing that X has sent him an email offering to sell his car to him, write him a message offering to buy that particular car. That's a cross offer. There are two simultaneous offers made on the same subject matter. So a cross offer does not create a contract. It does not create this contract. One person has to compromise their offer and accept the offer of the other for there to be a contract. A conditional offer is a condition which is made subject to certain conditions, which must be fulfilled before the acceptance of that offer. So it could be conditions based on timing, that the offer has to be accepted on Friday at 2 p.m., which means this person tells you that he's offering to sell you his laptop, but you must accept to buy it by Friday 2 p.m. That's a conditional offer. So if you don't accept the offer within that period of time that he has stated, then the offer comes to an end because it's based on that conditions that being fulfilled. Single offers and standing offers are commonly used in procurement or tendering processes. And a single offer is where the tenderer would be required to supply a definite quantity of goods and is supposed to do so within a specified period of time. It could be supposed to deliver or to supply 20,000 bags of maize from January, maybe from 20th January to December 20th, right? A standing offer is where the tenderer will be required to supply within a specified period of time goods not exceeding a certain limit. So it's supposed to, the period to which the bags of maize will be supplied has to be specified. This one is, say, for example, 1st January up to 31st July, bags not exceeding 1,000, which means that he can deliver even 50, but he cannot deliver more than 1,000. Then in terms of offers, we have termination of an offer. So there are several ways in which, there are several reasons that would cause an offer to terminate. One is revocation. An offerer can revoke or withdraw an offer, and he must do so before that offer is accepted. Once an offer is accepted, it has created the basis of a contract, and if the offerer was to decide to terminate it, then that would lead to breach of a contract. Then an offer can also be terminated by rejection. So when an offer is made to an offerer, he's not under any obligations to accept that offer. He may refuse to accept it. Refusal to accept the offer is what you're referring to as rejection of the offer. Then you have a counter offer, and I had alluded there before. A counter offers is a variation of terms of the offer, or a changing or a modification of the offer itself. And I've said that the consequences of counter offering is that it terminates the original offer. And you have lapse of time. So if an offer is made and it's supposed to be accepted within a certain period of time, and it's not accepted within that duration, then it comes to an end as a result of lapse of time. So where there is no duration that is specified, an offer will lapse on expiration of a reasonable time. Then an offer would also come to an end by acceptance. Once an offer is accepted, it will terminate the offer because a contract has already been created. Then failure of a condition. So if an offer is made subject to the fulfillment of certain conditions, and the offeree is not able to fulfill those conditions, then it will have an effect of terminating that particular offer. Then we have supervening incapacity. So, for example, incapacity such as like someone made you an offer, but they're declared insane or bankrupt, or they are professionally disqualified, it will have an effect of terminating the offer. Then death will terminate the offer as well, and especially where the offer is to offer personal services, it would have an effect of terminating that particular offer. All right. Any questions so far? Are we together?
Yes.
I have a question.
Yes, ask.
Will you kindly repeat under the acceptance?
Or on the, all right, on the on how acceptance terminates an offer.
Yes.
All right. So you have made an offer. You're selling a car for 450,000. The person whom you're offering has accepted it. All right. As a result of
Yes.
that acceptance, a contract is created, which means the offer is terminated because the offer will be revoked by the subsequent acceptance of it. Because once it's accepted, it will form the basis of a contract, right?
Yes.
All right. Any other question? All right. So what we do here, I want to share some questions here.
So I think there is where the counter offer comes in, the take it or leave it basis.
Okay. All right.
Yes.
All right. So very good. So she has contextualized that on the fact. She said that Tajiri had offered to sell it at 500,000, but Tajiri, it was who? There were two parties here, Mdosi.
See.
All right. So Mdosi is the one who's the offerer. So he said that he can only accept it if it's to be sold to him at 450,000. So that is the context of the counter offer in the question. So the other question we would ask, how would, having said that the question is on counter offer, and therefore because of the counter offer, we said the effect of it is that it will terminate the offer itself. What would we advise the parties? Because both of them, Ndosi is not happy that that Mtajiri went ahead and sold the car to someone else. Now, what do you advise Mdosi in this case? That's the other question. What do we advise Mdosi? Mdosi is the offerer here. The
Yes.
fellow who, yes, the fellow who counter offered. What do we advise him here?
Can I try?
Yes, indeed.
What I would advise Mdosi is to move on and search for another car, since even if he came up with a proposal of wanting to buy the same car at the agreed amount, the agreed contract was already terminated, so it was null and void.
Okay. It actually did not exist, right?
Yes.
Right, very good. Right. Any other person with any other opinion on the same? So in advising Mdosi here, you must identify whether there is a contract between him and Tajiri, and how we will be able to determine that is saying, since he counter offered, and therefore because of the fact that counter offer terminates an original offer, it means that there was no offer to be accepted because it was already withdrawn because of the counter offer. It basically means there's no contract between the two of them, and therefore, even if Mdosi decided to sue, he will have no basis of a suit, given the fact that the contract does not exist between him and Tajiri. All right, so this is the answer I gave him. This question addresses offer and acceptance in a contract and termination of an offer and the consequences of such termination. Tajiri's offer was to sell the car at 500,000. However, Mdosi's response was he could only buy the car at 450,000. This constitutes a counter offer, which basically means a change in the terms of the original offer. A counteroffer terminates the original offer unless the counteroffer is accepted by the offer. Tajiri in this case did not accept the counteroffer, and this means the offer was terminated as a result of that said counteroffer. So the consequence of this is there is no offer to accept, therefore there is no contract between Tajiri and Mdosi. Like we have said, advising both parties, is Mdosi, there is no contract between the two of them, right? So Mdosi would have no basis whatsoever of a suit against Tajiri should he decide to pursue legal action for breach of contract against Tajiri. All right? You see how to answer such? Huh?
Yes.
Okay.
I have a question there.
Ask.
What if Mdosi had agreed the initial offer of $500? Yet Tajiri went ahead and still sold the car to the third party.
All right. Very good question. Huh?
Yes.
It's very good. So someone asked, what if Tajiri had made the offer for 500,000, Mdosi had accepted that particular offer? What would have happened if Tajiri decided to sell the car to someone else? Any person with an answer? Tajiri has made an offer and Mdosi has accepted that offer. But Tajiri goes ahead and sells the car to someone else.
Legal actions.
All right. So, is there would you say there was a contract between the two?
Yes.
There will be a contract if at all they write it down.
No.
Really? Is that true?
No.
Right. Well, yeah. If you say no, why? Why?
As from the definition you have said, it's an agreement or promise which is legally binding and enforceable. And it doesn't have exactly to be in writing, but if the person gave his acceptance on selling the contract, even if it's orally, and then he goes and still breaks it, there was still a contract over there, even though it wasn't on writing, but it was done orally.
I don't know. All right, very good. I don't know who had said that a contract has to be in writing. Is it Dorcas? Have you entered into a? Do you think? The question is, have you entered into a contract ever?
Yes.
Eh? You have?
Yes.
What kind of contract was it?
Job at my workplace.
An employment contract?
An employment contract, yes.
You have never entered into another?
No.
Really, Dorcas? Really? Have you ever bought food in a hotel?
Yes, I have.
Why would you think that's not a contract, Dorcas? So you're saying in your lifetime, have you ever bought something in a shop?
Yes, I have.
Yes, that's a contract, Dorcas. A contract does not need to be in writing for it to be said to be so. Right? So the idea, the fact that they had not written it down would not negate the fact that there is a contract. He has offered to sell the car at that amount. The other party has accepted to buy, then he decides to sell it to someone else. That is the basis of breach of contract, because there's already a contract between the two. Now, Neema, there is
a question on that. Okay, basically when we say about the Mdosi, and what if maybe they had a contract, but now that he sold the car, then he goes and sues him. He doesn't have the legal proof that they had a contract between. It was only by promise. So can he be sued, being that he doesn't have the legal proof that
Binding.
they had a contract? Yeah.
So you asked whether there was. So you say that because it's not in writing and it's only between the two of them. I suppose the good thing about a written contract is the fact of steadily. You have proved that a contract existed. So if it's made orally, you would be at task and at pains perhaps to prove the existence of it. But it doesn't mean that just because you have entered into a contract orally, that it is not a contract. All right? There will be other ways in which you will prove that there is a contract. all right? But a written agreement, of course, is better than an oral one, but it is not only, it's not always possible to have a written agreement. There are things you cannot, like, can you imagine every time you go to a hotel to eat a meal, you have to write it down, just to be, can you imagine how chaotic it would be? Or when you enter into a supermarket to buy, which is basically also a contract. Can you imagine a scenario where you would be expected, first of all, to have a written document where you sign saying that this is the things I want to buy? How would that even work? Right? I'm not. It's oral contracts exist, and I think I suppose what I want you to find out are what are some of the disadvantages of an oral contract, and the other one I would want you to find out what are the advantages of a written contract. All right? I think that will help us understand from a deeper level this kind of to be able to answer those kind of questions. There's someone here who is asking a question. Let me see. Nema is saying she's asking whether there is an oral contract, and she also says it must be made. She thought that it must be made in papers and signed. No, it doesn't. Contracts can be implied. They may be expressed. They may be in writing. They may be slightly, partly in writing and partly oral. But I did mention that there are certain contracts, for them to be valid, they have to be in a certain form, like insurance contracts. Because when you're entering into an insurance contract, it is based on the policy document, which will have the subject matter. It will indicate the parties, the risk you're insuring, the premiums that you are going to pay. So it's based on that written agreement, right? So that forms the basis of the contract. And I had also mentioned hire purchase agreements also equally must be in writing. But there are contracts that are going to be oral, right? Someone has promised to sell you a laptop, right? You have accepted to buy the contract, the laptop. They sell the laptop to someone else. Just because you have entered into it orally does not mean that a contract does not exist. It actually does. All right? Any other person with a question? All right, so if there is no other question, let me proceed with the next portion of contracts. Where was that? All right, so I don't know, I was not recording. So having talked about the offer, the other thing or the other process that this particular offer has to undertake is that it has to be accepted. So an offer is made by the offerer, then the offeree has to accept it for there to be a contract. So acceptance is actually the expression by the offeree of his willingness to be bound by the terms of that offer. And an acceptance actually does complete the agreement itself. So it forms the basis of the contract. And if all the other ingredients of the contract are present, it will basically conclude that contract. All right? And then we have consideration. So the consideration can be said to be the price for which the offer is bought, or something in return of something, or what referred to as quid pro quo, something of value before the law, whereby the offerer is aimed to derive an advantage. So both of these parties have to derive an advantage from the contract itself. All right. So Nema, I suppose I will check your settings because I think the others. Can everyone hear me?
Yes.
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 Nema, check your settings. Let me tell her to check her settings. All right, so all that constitutes consideration. The price you have to pay within a contract, something of value before law, and it's the advantage that a person is going to derive from an offer is what your or from the contract itself is what your consideration will be. Like I was saying, the consideration in terms of the buyer, because the buyer has to pay a price, and therefore the price he pays will be his consideration. The goods that the seller is supposed to deliver to the buyer is also his consideration. Something in exchange for something is what consideration is. All right. And so there are these types of consideration. So we have executory or future consideration, and the executory one is a promise to perform an action at some future time. Executed consideration is where one party has made a promise in exchange for an act by the other, and when the act is completed, it is executed consideration. So X promises or offers to sell 10 bags of maize to Y for 100,000. The 10 bags of maize is delivered to Y, and Y pays the amount. Executed consideration. So you made a promise, and you have completed that promise, and the other party has also executed their consideration. Then we have past consideration. So after negotiation, and once you have made or you have negotiated and you have arrived at an agreement, which means that you have created a contract, any promise that is made after a contract is made is what you refer to as past consideration, or any promise that is made after a service is rendered. Past consideration does not constitute a valid contract. All right. So when you have once you have made an agreement, all right, it's like a farmer sells you a cow, and you negotiate and you buy it for 30,000, and you agree and you pay the amount, and as you're going away with the cow, he promises that the cow can produce 10 liters of milk per day. Now, if you go with it and you find that it cannot, the fact that the promise was made after a contract, the contract had already been made, means that the promise that he has made to you is past consideration, which is not enforceable. So you will not sustain a suit based on that promise made by the farmer. Should you go with the cow and you find that it can only produce like 5 liters of milk, all right? So past consideration is not valid. It is only going to be valid, for example, if when he promises you that the cow can produce 10 liters of milk per day, you in exchange of that promise, you promise that you'll pay him an extra 2,000 should it produce that milk. So that again forms the basis of a contract. All right. So should you go there and you find that it can only produce 5 liters, then you would sustain a suit. All right. Then there are certain rules of consideration. We have performance must be legal. the court will not enforce a contract if the basis of that contract is actually legal. The performance must be legal. You must agree to perform only that which is legally and physically possible. Then consideration must move or pass from the promisee. So the person who is wishing to who wishes to enforce a contract must be able to show that they also have provided consideration. So the promisee must be able to show that that some consideration moved from them, and only those persons who has personally given consideration for a promise can sue for a breach of promise, right? And then consideration must be sufficient, but does not need to be adequate. So adequacy of a consideration is, say for example, the market value of a house. If the market value of a house is 10 million, if you're selling it, that would be the adequate price, right? But contractual freedom means that it's possible that the market value of a house is 10 million, but you, because of that contractual freedom, you can be able to sell it for a lesser amount. That lesser amount is what we refer to as the sufficient consideration. And courts are not going to investigate whether you, as a person or a party in a contract, you are able to get an equal value. The assumption is that based on the contractual freedom, that you are able to negotiate for the price that you wanted. Only where there is perhaps misrepresentation, mistake, undue influence, perhaps would the court interfere in that. Then consideration must be something in excess of a public duty. So a police officer, normal duty is to keep law and order. So he will not get an extra pay unless he does something that is beyond his duty of keeping law. Consideration must be in excess of an existing contractual obligation. So you're supposed to work from 8 to 8, from 8 to 5, and you work from 8 to 8. Then you have done something in excess of your existing contractual obligation. So you'll be entitled to a pay for the 3 extra hours that you have worked. The love and affection cannot be consideration. And then finally, you can promise an affection in exchange for something. How do you even quantify that? Then you have payment for
Excuse me, Mwalimu.
Mhm.
Excuse me.
All right.
We are really struggling to hear what you're saying. Will you please be louder, please? We are really struggling to hear what you're saying.
Okay. I was saying, love and affection cannot be consideration. And then I have also mentioned this last one here. Payment of a lesser sum than owed does not make good consideration. So if someone promises to pay you a certain amount, right? So if you're selling goods, the goods you are supposed to be paid 400,000, right? If you're paid a lesser amount, say 250,000, as opposed to the 400,000, you have a right to receive the whole amount, right? So where a person has paid you a lesser amount, it does not discharge, or it does not bring to an end the obligation of the other party to actually pay you that whole amount. We call this the Pinel's rule, right? And so you are saying, I would want you to go and read on the Pinel's rule, the case on the Pinel's rule, so that you'll be able to understand more on what the concept of payment of a lesser sum than actually someone owes you does not fulfill the obligations to pay that particular balance. Of course, there are exemptions where payment of a lesser amount is going to form the basis of a valid contract. So one, where the money is paid earlier than the date due at the promisee's request. So the person who owes you money, someone owes you 450,000, they're supposed to pay you on 30th June, but you ask them to pay you today, right? Because you are facing some financial challenges, right? Remember, the amount is supposed to have been paid on 30th, but you request for them to pay you, instead of the 400,000, you request them to pay you 300,000. Now you will not have a right to receive the balance because you have requested the money to be paid before the due date, all right? And where the payment is made in kind, someone is supposed to pay you 20,000, but you ask them to give you a phone that they are using in exchange for that debt. Suppose the debt is 30,000, the value of the phone is 25,000. You cannot ask them to pay you. You not ask them, based on these rules, you will not be able legally to seek to be paid the balance of the 5,000. And then composition agreements in bankruptcy proceedings. And then where someone who's a debtor who's going through bankruptcy proceedings has enough creditors that he owes money, right? He promises to pay them a lesser amount than he actually owes them, all right? They cannot later on come and seek for those balances, because now that would terminate his obligation to pay them the obligations. And then where payment is made at a different place, other than the contractual agreement at the creditor's request. So A is bound to pay B 1,000 in Mombasa, but B requests for it to be paid in Nairobi. So he requests to be paid 800 in Nairobi, as opposed to the place to which the amount was to be paid, which is 1,000. So where the mode of payment is also altered at the promises request. So the money was supposed to be paid in cash, but this other party has requested that the money be paid by M-Pesa, where you receive a lesser amount than is actually owed. That will terminate the obligation of the other party to actually pay the balance. And then where the payment of a lesser amount of money is paid by a third party, and the promises accept this as full and final payment. So A owes B money. B's father decides to pay A's the debt, but the amount is less than he actually owes, than the son owes. If A accepts, then he cannot sue B later on, because he has accepted the payment from the third party as a full and final payment of that debt. All right? Now those are the rules in consideration. So the price you're paying or something in exchange of something is what we have referred to as consideration. And we said rules of consideration consist of the fact that the performance must be legal, performance must be possible, consideration must move from the promisee, consideration must be sufficient. Although it does not need to be adequate. So what is required is that the consideration is to have some value in law in the eyes of the court, which means that it will be sufficient. It does not need to be adequate. Consideration must be in excess of something, of a public duty. Consideration must be in excess of an existing contractual obligation. Love and affection cannot be consideration. And finally, payment of a lesser sum than owed does not make good consideration. All right. George?
Yes.
We have heard that?
Yes.
Yes, all right. So before we move forward, let me share a question here for us to have a discussion on this. All right, so you can see that. So the question reads, again, our rules abound. I read the question. I expect participation. You can use the chat, or you can also speak. All right, so Kioko runs a hotel business where he specializes in local foods. For 5 years, his business has done pretty well. In February 2019, he borrowed 500,000 from his friend Muturi. The agreement between the two was that Kioko would pay the money borrowed in November 2020. However, Muturi is in dire financial distress as a result of COVID and is to be auctioned if he fails to pay the debt. To pay a debt he has with the Faulu Bank and wants the money paid immediately. He approaches Kioko, who can only raise 350,000 due to the short notice given. Muturi is okay with it and accepts the amount as a final and full payment of the debt. Kioko wants to make sure that the agreement is sealed and Muturi will not come November 2020 claim for the balance. According to the law of contract, explain to Kyoko the legal issues applicable in this case and advise him on the possible outcome. All right, so you can endeavor to read the question some more. All right, as we proceed to answer it. So we must identify what the question is about and then give context on the basis of the facts in the question. Anyone?
Can I try?
Yes, indeed. Go ahead.
First of all, we see that this is a consideration. We see that Kyoko, despite of him borrowing money of the amount 500,000 from Muturi, before the due date, she was, however, asked to pay Muturi 350,000 because he was in dire situation. And Muturi, having given his consent that it will be the final and full payment of the debt, Kyoko won't be obligated to pay the full amount as I'd agreed, since you have seen under the exemptions of the penal rule and the composition agreement. If Muturi had already given the consent that 350,000 will be the final full payment of the agreed amount, therefore Kyoko is relieved from such contract, since he is already, how will I say, is not obligated to finish paying the amount come to November.
Okay, great. Thank you. Very good. Very good, Daniel. Any other person with contribution? Kelly, your microphone is on. Do you have anything to say? Any other contribution on the question? There's no other person with any other besides Daniel? Milka? I suppose Daniel has said very poignant points here. He has mentioned that Kyoko is not obligated to pay the balance. What I would have wished him to state is why. Why is he not obligated to pay the balance? That before you even give context to that particular issue, you would have to identify why the issue at hand. it is Daniel.
Yes.
Yes.
Sorry.
What is the? Did you tell us what the question is about before you gave context? You said it's consideration, but you see, consideration is in itself. It cannot be. What part of consideration would is the question? The issues about
Can you? It's a future consideration.
future consideration.
Yes, because
Mm-hmm.
we are being told you will be allowed to pay the agreed amount,
Mm-hmm.
of which it was supposed to be on November.
Mm-hmm.
So since it's something that's to happen in future, it was supposed to be a future consideration.
All right. So Daniel says that the question is based on future consideration. Any other person with a different opinion?
I think the question addresses the Pennies rule.
All right. Why? Kelly, you are telling us something very important. And you are right. The question addresses the Pinel's rule. But specifically, what part of the Pinel rule?
The exception of the one was credited the money can pay lesser amount before the due date.
Or before the due date?
Yeah.
Okay. All right.
I think that's the case of the question, according to my own.
Very good. Very good. Okay. What's it, Kelly? Kelly says that the question addresses the Pinel's rule, and exactly what the question addresses is the exemptions in the Pinel's rule. All right. We have said that the Pinel's rule is where you would, if someone owes you money, in the Pinel's rule here, to put context in this fact, is that payment of a lesser amount than owed does not terminate the obligation to pay the balance. So here, the money owed to Muturi is 500,000. So ordinarily, under the Pinel's rule, he would have a right to receive the 500,000 from Kioko. However, we have mentioned that there are certain exemptions. So this question addresses that exemption, that where payment is made and it is to be paid, where payment is made, where the promisee requests that the payment be made before the due date, then it means that the payment must be made. I mean, it will terminate the obligations to pay the balance. And because this is what happened, Muturi would not have a right to claim the balance or the 150,000. Okay. So your advice to Kioko therefore would be what? Those are the legal issues addressed there. What would you advise Kioko? Daniel, what did you advise Kioko here?
I advised Kyoko not to pay the remaining amount sum since the contract is not applicable to him.
Okay.
It was already.
All right. So he will. Your advice to Kyoko would be that he would not be obligated to pay the balance because of the exemptions, under the Pinel's rule. All right.
Yes.
Very good. There is no question here on. What else did I want us to do today? Mm. All right. So in the remaining period, I'm posting the assignments, assignment 1 and 2. Is there a question on contract so far?
Excuse me, madam.
Mm-hmm.
Can you post the 2 questions now in our WhatsApp group? We can go through them.
Okay, I will. Let me do that
Thank you.
before I forget. I will post them. Meanwhile, I will be posting the question 1. Assignment 1 and 2 on Moodle. I expect the assignment to be submitted by 23rd of this month. So that is well noted. But I will note it on Moodle. Then on assignment 3 is going to be a multiple quiz. All right, to be 10 questions, multiple choice. I expect we will do that next week. I will post it on Monday, and I'll give you 5 days to have done it. So sorry, it will be available from 13th. 13th. But I can post it. It will be available on 13th, 14th, and 15th. 3 days to be available. So use these days to be able to read for it. It will be based on those topics that we have handled: the role of persons, introduction, the sources. Yeah, those 3. I will not examine you on the role of contract. So, but prepare for that. That will be assignment 3. And so that will make assignment 1, 2, and 3. All right. Okay. So if there's no question, I will post the recording on Moodle. So for those that were not able to be, that were not there at the beginning, you can be able to have a listen and perhaps listen and go through the notes as well. Okay. All right.
Yes.
Okay. So
Yes.
make sure you look at the Moodle. But I'll post on Moodle on your WhatsApp when I do post them. If I don't, I wouldn't have posted the questions that have been requested. Kindly remind me. There is a lady there who has requested that I send the questions. Kindly, if I would have
Yes.
sent them by tomorrow, kindly remind me.
Okay.
Kindly remind me. All right. So I think I suppose let's call it a day and meet next week. The recording will be available on Moodle. Okay.
Okay.
All right. Bye.